Welcome back to the program. All right, maybe we have a bright spot with this Supreme Court. Nothing can undo the damage in this last week. But the court has decided to take up a case. It's a very important case that could potentially tee up what looks like national right to work. Now, specifically, national public sector right to work. I'm going to let Mark Mix, who actually has been with this case, understands the ins and outs of all of the different cases that the Supreme Court is going to look at. This is the Friedrichs case out of the state of California, and the United States Supreme Court has agreed to hear this case. Mark Mix from the National Right to Work Foundation is on the phone with me now. So, Mark, am I wrong? It's public sector, right, is what this is going to be addressing as a case.
That's exactly right, Vicki. This is an extension of a case that the National Right to Work Foundation won last year, a case called Harris v. Quinn that came out of Illinois. And that case built on a case that we won in 2012 called Knox versus Service Employees International Union. And basically this gets to the question of whether or not everything government unions do is political. And if it is political, then you can't force someone to support that political speech because it's First Amendment protected. The notion that unions, government unions, are lobbying government, they're redressing government, they're changing the way government acts based on their actions, and they're talking about government action, i.e. political talk. Therefore, the First Amendment will protect these workers that are compelled to pay fees in order to keep their jobs across the country.
So that's the logic, that everything the union engages in when it is negotiating for collective bargaining agreements or threatening is a political activity because we're talking about the government, because the only way to compensate the union is to take taxpayer money. That is explicitly political.
Yeah, and that's where Justice Alito has gone with this in the question that was presented to the court in the Harris case. And what happened there, we got a 5-vote majority agreeing to this line of reasoning. But in the case of Harris, we had a very specifically designated group of employees, home health care employees. And so what the court did there is they answered this question, but they said we've got a specific identified group of employees, and so we don't need to go any further. What Friedrich does, what the Center for Individual Rights has done, which brought this case in California, kind of through an interesting legal strategy, not contesting the outcome so they can expedite to the U.S. Supreme Court, has brought the court now a group of state employees, official state employees, teachers, etc. And they're saying, apply the Harris Doctrine to these state employees and strike this compulsory union down.
Okay. In the Harris case, the one you guys were involved in, that was SEIU attempting to force people who previously were not considered part of a union into essentially what functioned as union members without union rights, correct?
That's correct.
Okay,
These
so
were home health care. Yeah,
a different type of group here. People who were not actual forced union members, we're not, they actually didn't have the same rights as other union members. This is kind of interesting to me that the court was so expansive this week in stretching its definitions. And yet in this one particular case, you know what, we're just going to keep it just to this tiny little group, this little subset of employees, home health care workers. We wouldn't want to actually extrapolate our logic out to state employees or anything like that. But this is the new case that would ask to see that same exact logic applied to a much larger and existing class of union employees.
That's exactly right. And going back to those home health care workers in Illinois, they were actually considered state employees, but specifically for the purpose of extracting part of the Medicaid payment that went to these recipients who were getting personal health care from, in the case of our plaintiffs, 8 mothers who were taking care of their own children. They were considered, quote, union employees for the purposes of extracting this fee, but to your point, Vicki, they didn't get anything else.
No, this is the kind of slimy tactics that the unions engage in that get, these same politicians who act as their agents, in this case, the governor of Illinois, the legislature of Illinois, were willing to take Medicaid payments away from parents and people taking care of their own relatives to give it to the SEIU, and then call those employees for the purposes of paying union dues, but they had no voting rights. They had no say over collective bargaining agreements. They couldn't vote to throw the union out. The SEIU wanted money. They thought they could get a few $100,000 a year out of these workers, and they wanted to see if that strategy would stick so they could do it in other states.
Yeah, actually, they got millions of dollars each year, and the schemes extended to 18 different states. And so the Harris case actually protects home health care workers in what was 18 states that had similar types of schemes. So the court did go in a more broad sense. They said you can't do this anywhere in the country for this type of situation. But they did not. They said they didn't have to go to all government employees because they had this identifiable group of employees here. But you're right, Vicki. In the Oberfeld case, basically the U.S. Supreme Court says we're gonna overrule all the states on this, and it's kind of ironic because the people on defense in this case are arguing that the court shouldn't tamper with these states' rights.
Well, yeah, and the same people would have argued the court should tamper with states' rights.
Exactly.
In any other case that would affect them. But it's a First Amendment case. It really is kind of easy to see it as a First Amendment case. Here's my concern, and I'm sure it's yours and Center for Individual Rights as well. The Harris case was 5-4. How did 4 justices actually think it was okay to extract Medicaid dollars from people who are poor, taking care of their relatives just to line the union coffers? I mean, so if one more decides to adopt that logic, let's just say Justice Kennedy decides to adopt that logic, then this is not going to go anywhere, and ultimately it's rubber stamped the abuse of the First Amendment yet again.
Yeah, that's right, but we don't really lose any ground because that's where the court has stood in a 1977 decision that was our court case, a case called the Booth, which would be overturned by this decision. Basically, what we did in the public sector there is we separated the political component, the identified political component, from the representational component, and we got the protections for public sector workers in 77 that has been basically in place since then. This question goes to the entirety of union speech, and hopefully they'll get there and say that everything they do is political, therefore protected by the First Amendment, and they'll strike it all down.
Let's hope so, because to take the political component out, you had to trust that the union was being honest with you to take the political component out, and that has, given the massive amounts of money that has gone into politics, just explicit politics, Mark, and the very, very tiny amount of dollars that have been remitted back to workers who have attempted to assert their rights. That it's quite incongruous, shall we say. So it looks like Abood was just simply, they circumvented it. They tried to figure out a way just to get around a 77 decision. This would strike it down. But it doesn't mean anything for private sector, correct?
That's correct. I mean, this case is specifically about public sector workers, but you'd think as we begin to work through this process that you could make that argument. You could go back and make that argument. But way back in the 1930s and 1940s when they established the federal labor policy, they established the notion that industrial peace was more important than individual rights. And so this industrial peace platform has basically superseded the individual rights of a worker to speak or not speak to a union that they're compelled to pay fees to. So we'll see what happens in the private sector, but in the public sector, it'd be good enough. That'd be a good first step for sure.
That's really where the only growth in unionism, can even be measured right now is the public sector. It would essentially be National Act 10.
Yeah, that's right. Wisconsin sparked the interest in this, obviously, and this is an extension of that for sure.
Absolutely. Now, let's talk about some of the ways that the unions are trying to strategize against this decision. You probably, lurk and troll this particular publication. In These Times is the name of a radical pro-labor publication, and there are any number of different ways that the unions are trying to circumvent what might happen with the Supreme Court, not to mention trying to figure out ways to utilize their lock on the National Labor Relations Board to see if they can unwind any protections that already exist in private sector right to work.
Yeah, that's exactly right. And the National Labor Relations Board is expanding their kind of authority, quote unquote. I'm using fingers in the air here over these issues. In fact, we just testified in Congress about 3 weeks ago about a design by the NLRB to start charging non-members in right to work states fees, union fees, and so. There's lots of work to get around this stuff. They know they're in trouble. This is a privilege that's been granted them by government, both in the private sector and the public sector. And, you've got to play politics in a big way to protect this stuff. That's what they're doing. But certainly, after we did Abood in 1977, a lot of our cases were representing individual employees who would stand up and exercise their rights. And you couldn't believe the obstacles that were put in front of workers to actually get their rights that were articulated by the Supreme Court in that case. In that case, in 1988 that we won for private sector workers, we still have to litigate to this day about what is or what is not chargeable. The unions continue to try to hide that from workers. They create window periods, obstacles, all kinds of things to keep folks into this forced collective.
Absolutely. At least keep collecting the money until they're absolutely, forced to give it back or to stop kicking and screaming. You have a case in Wisconsin, as I understand, a couple of people who have tried to exercise their rights under our new right to work law, who have been told that they have to do it only during certain times, and it has become very difficult for them to get any information. And this is pretty typical of what happens in these right to work states when unions try to balk at actually letting people out of the union.
Yeah, that's right. And it's an important role to play in enforcing the law. I mean, the law is only as good as the enforcement of it. And so the neat thing about the foundation's work is these workers who want to exercise their rights can come to us and get free legal services. Now, if they had to go get a private lawyer and pay fees to a lawyer to get this done, sometimes it wouldn't be worth it because the union dues are on average $800 and $1,000 a year. Any attorney worth their salt is charging, some of them in Washington are charging at least that per hour.
Yeah, not per year, per hour. They want $1,000 back a year, and you've got attorneys that are charging per hour. National Right to Work Foundation actually provides assistance to workers on a pro bono basis, which is the nice thing. You look for these cases. Do these cases look like they're winnable? Is it worth taking a run at the question? And little by little, since you guys have been in existence, you've managed to wrestle away the control of the unions and put it back into the hands of workers. What would be the step to try to then, let's just assume that happy days are ahead and the Supreme Court agrees with the Friedrichs case, with the argument in the Friedrichs case. How then do you go about trying to, expect the same thing for private sector when the National Labor Relations Board right now is being asked and is considering imposing what are agency fees, which were I thought the Supreme Court ruled against that, but are trying to impose agency fees in right-to-work states to undermine any protections under right-to-work laws.
Yeah, that's right. But what would solve that problem would be our National Right to Work Act. The National Right to Work Act that's introduced in the House and Senate right now doesn't add one single word to federal law. It simply repeals that authorization for forced unionism that's applied in the private sector across the country. Wisconsin's action, when they passed a right to work law, what they did was they used an exemption from the, quote, federal preemption to outlaw compulsory unionism in Wisconsin. So the federal law is what establishes forced unionism, and so the National Right to Work Act would take that away from private sector employees. So
the whole reason states have to battle is because the federal government says states have to battle.
That's exactly right. The federal government created this in 1935, and
gave itself the authority to hang up the states.
Yeah, that's exactly right. Yep.
All right, one last thing. Is there anything that can affect exclusive representation? Because I'll tell you what, I'm kind of tired of hearing about the free rider argument when the unions have the right to exclusive representation of a labor force.
Well, I think the solution to exclusive representation is to give workers the choice of whether or not to pay a union. If you're a union official and there's right to work laws, I think you should start wanting to represent only those workers that would want to join you voluntarily. I think the revenue picture is what drives the monopoly bargaining desire for organized labor. If you change the revenue structure, you change the way they're going to do business. And at that point, they become a voluntary organization representing their workers that want their representation, and they become much better at doing what they claim they do, and that is representing workers on a shop floor.
Mark Mix, the National Right to Work Foundation. I do appreciate the time today. When do we expect to hear the oral arguments on this case?
Based on the timing, probably November or December of this year, and then likely a decision anytime in 2016, probably waiting all the way till June again, because it is an important case, no question about that.
All right, so oral arguments in the late fall, early winter, and then another summer decision on it, just like this time around. Mark Mix, thanks very much for being on the program today. I very much appreciate it.
Thanks, Vicki.
And have a wonderful Independence Day. I need to take a break. We'll be right back.